We do have one final case on our docket this afternoon. That is Laguerre Appellant versus JBS USA Holdings, Inc. and American Zurich Insurance Company Appellees. That is case number 242049. Appellant is represented by attorney Andrew Bribriesco, and the appellees are represented by attorney Andrew Workman. Mr. Bribriesco, whenever you're ready.
May it please the court staff present, counsel. My name is Andrew Bribriesco, and along with Gabriela Navarro, we represent Laguerre. The largest organ in the human body is the skin. This is an anatomical and medical fact. The legal issue at play in this case is something that has not been addressed since the 2017 amendments. And that legal question is, does a permanent and rateable injury to the skin, which is not attached to the face or head, constitute an unscheduled injury? As we know in the Workers' Compensation Act, there is a list of body parts in it. We call it the schedule. All of the fingers in the hand are on the list. The hand is on the list. The arm's on the list. The leg is on the list. Injuries, permanent injuries to the skin at the head and neck level, the head and the face, are on the list. The list is the list. If there is a permanent injury or loss of use to a body part or organ that's not on the list, we call it an unscheduled injury. Laguerre argues that the permanent injury, the loss of use that he sustained to his body, is not on the list. And therefore,
muscles aren't on the list and bones aren't on the list. And I think technically bones are considered an organ as well. And we understand the list to mean everything that's a part of your arm, including the muscles. Why isn't skin like that?
The skin is a different body part that's listed in the AMA guides. It's a chapter 8. Everybody at the agency level concluded that chapter 8 was the appropriate chapter. And the legislature knows the difference between the two. As I mentioned, if there was a permanent skin injury to the face, that would be on the list. So I think we could all agree here that if Laguerre had sustained a concussion or an orbital fracture, that would be unscheduled. Likewise, if we would all agree here that if he sustained a degloving or a permanent injury to the face, like his cheek, that would be scheduled. So we know the legislature knows the difference between the skin, the organ of the skin, and the anatomical structures below.
Even the permanent disfigurement doesn't mention the skin, though. I mean, the skin doesn't show up anywhere in the chapter as I see it. I mean, I agree with you that permanent disfigurement would affect the skin, but I wonder why wouldn't we also say that, skin on the arm, is affected when there's an arm injury?
As I said, I think a permanent injury to the skin, I believe, is synonymous with the disfigurement. This is not something that's unique. In jurisdictions such as Illinois and Minnesota, they specifically list these types of injuries to the skin in their schedule. Now, the reason why things have changed is because we have 8534-2X. The legislature wanted to restrain the agency from using its discretion in determining the loss of use of body parts. And we know from the Chavez case that positively they wanted to align medicine with the law. So in that case, a shoulder was a shoulder because the AMA guide said, well, it's an upper extremity. Well, in this case, and I'm going to talk a little bit about the facts if that's okay, just to kind of get back to it. What we have here is purely an injury to the skin. We can all agree it's sort of a unicorn type case because most injuries that occur that involve a huge degloving type injury, usually it affects tendons, muscles, bones. That didn't happen in this case. Laguerre was a meatpacking worker. He was a coworker accidentally struck him with a wizard knife, and the wizard knife is intended to take off skin and fat from a pig. And that's what happened. It was a complete tearing off of the skin. A degloving injury, which is in the medical records, is essentially if you were to have a glove and you took off that layer of skin. Sorry, I believe you have a question. Yeah.
Puzzlement on my face. I'm just sitting here thinking about scheduled injury. Somebody chops off my index finger, right? Scheduled member. But there's obviously, when you chop off a finger, there's skin left with some deformity to it from that injury. But I don't know. I guess my question is, if I take the approach that you're suggesting here, how do we ever have any scheduled member in those kinds of situations? Isn't that always going to convert what would be the lack of a scheduled member or an injury, taking the entire scheduled member off, now is an unscheduled injury?
Great question. And I think it goes to the idea that, is this double dipping? Is this what's going on here? The answer is it would be inappropriate to get a skin rating under that scenario. The AMA guides would require, and remember, the legislature delegated to the agency the AMA guides as the determination of permanent impairment, that it would be a injury to the finger. The chapter 16 that rates hands and arms, that's a different chapter than chapter 8. And the AMA guides says it is inappropriate to use that and this. So we do have a unique situation. As I said, this is a rare case where we have all the experts, the defendants, and Laguerre's expert all agree chapter 8, the skin chapter, is the only applicable chapter. And the agency found that was the right chapter to be used.
I agree with you. I mean, it seems to be unique that here it was only Chapter 8, but as I read the AMA guides, it looks like it contemplates Chapter 8 would be added in whenever there is a skin injury in addition, to a muscular injury or some sort of other piece, and there talks about how you combine those things together. So how is this limited to, your argument limited to only when it's purely a skin-only injury that we would be into the whole body arena?
That's correct, Your Honor. In fact, if in the thousands and thousands of workers' compensation cases where there's an amputation, you don't see a skin injury as well. This is a very unique type situation where we're dealing purely with the organ, that's the body part that was permanently injured, which is the skin.
So you put a lot of weight on the AMA guides calling for a whole body impairment. And I want to kind of probe that a little bit too. I mean, as I'm not an expert on the AMA guides, but as I've been trying to think it through, I mean, it looks like they almost always go to a whole body impairment, especially when you're combining from different body parts. So by that argument, like the facts of Bridgestone, where you've got two different scheduled injuries combined together, as I understand it, you would be using a whole body impairment to do that under the guides, but Bridgestone says that's still scheduled. So how do we wrestle with, and why should we give any weight to the whole body name or impairment that's caused by the guides?
The whole body impairment goes to the medicine, and the medicine does not permit that it's limited. They keep it as a separate treatment, a separate chapter dedicated to that organ system. And if you look in my brief at the, I believe I listed out the different classes of types of skin injuries. It is very different from the Chapter 16. It's very different from the Chapter 14, the arm and the leg. And in Anderson's a little bit different because those body parts were on the schedule. We're talking about an organ that's not on that list. In fact, and that's what we're talking about as a matter of law. The permanent impairment that they received was to this body, the skin. It was to the skin only. no tendon. There was no functional use. Chavez had to wrestle with, what is a shoulder? They found that a rotator cuff injury, reversing prior 2017 law, actually a rotator cuff will be a shoulder injury because they used a functional, they decided it had to be a functional use. Now, if we apply that rationale, it fits exactly right. Your skin is not needed for range of motion and for, it's not needed for strength. Under the AMA guides and under just medical common knowledge, it's to protect us from microorganisms, ultraviolet lights from the sun. The skin has a completely different function than an arm and a leg. And I believe I'm out of town. Oh, I'm good. Thank you.
Minutes on rebuttal. Thank you, counsel. All right, counsel, whenever you're ready.
Counsel. My name is Andrew Workman, here on behalf of the Appellees. And I believe the case before the court today is a relatively simple matter of statutory interpretation. The district court accurately captured the specific issue before the court being whether an injury, the effects of which are limited to a scheduled member under Iowa Code 8534-2T should be classified as unscheduled according to Section 8534-2V because the injury received a body as a whole impairment rating and primarily affects the skin. And here the Iowa Supreme Court has read Section 8534-2V, the catch-all section, narrowly, including in the Bridgestone decision. And the subsection 8534-2V applies only when an injury is not described or referenced in paragraphs A through U. And I believe it's irrelevant whether the specific injury here affects only the skin or also the nerves. If the injury is confined to that scheduled member, if the functional impairment, the situs and the impact on the ability of that member to function, if it's confined to that member, then the analysis ends there. And in this case, the appeal is only for corrections of error at law. The factual findings at the agency level reiterated by the district court are not contested here. And importantly, the agency found that the impairment here, the actual impairment of the function of the members was limited to the arm and the leg. There was not any impairment of function into unscheduled body parts or those that exceed the schedule.
In saying that that's the rule that should apply, you rely pretty heavily on the Delaney opinion, and your friend on the other side argues that that's different. It's a different statute. Can you address whether you think Delaney is controlling on us?
Absolutely, Your Honor. And I do believe that Delaney is controlling. How the court got to that question is different. There it was a question of entitlement to second injury fund benefits, but the question at the heart of it was the same. It was whether this injury, which received, in that case, it was a vascular injury of lymphedema, which the guides provide a whole person impairment rating for. Obviously, this injury also affected the skin to some extent, but the vascular injury is what received the rating. And there, the agency had ruled that it was pro se. Because this was a vascular injury that yielded a whole person impairment rating, then automatically it was a whole person injury or an unscheduled injury under 8534-2V. And the court clarified and said, no, this is not an automatic categorization there. We need to take this on a case-by-case basis and determine whether that loss of function, that impairment rating, the situs of the injury and the impairment, whether that's limited to members referenced or described in 8534-2A through U. And in that case, it was.
8564, right? I mean, there's a different list in the statute that Delaney was interpreting than the list in 8534, but you know, there's overlap between those. Has the court always interpreted arm, you know, under the one statute the same as arm under the statute we have?
I don't believe that there would be any distinction between those two, because I believe the question before the court was whether or not this is a scheduled member injury, and specifically those enumerated in 8564. But the question being, did this extend into the whole person, such as it would be compensated under 8534-2V? And the Delaney court endorsed numerous decisions that share very similar facts, including the Tapote case, where they endorsed that just because an injury is to the skin and the skin covers the entire body, that doesn't automatically mean it is an unscheduled or whole person injury. And also the Burke case, decided by the same deputy commissioner who presided over the arbitration hearing here, explaining very succinctly that the impairment rating is not the guiding factor exactly how it's expressed, but rather that it's limited to impacting the function of a scheduled member. And again, the Bridgestone court, I think, reiterated that by reading 8534-2V narrowly. Simply describing or referencing is fairly broad language, and such that I don't think it can be said that an injury that primarily affects the skin of the arm, I think one could easily say that it describes or references an injury to the arm, or a skin graft taken from the leg. Certainly the impairment there limited to that specific member, here the leg, and that being described or referenced in 8534-2A through U. So I don't believe it's
sort of fact-driven question. I think part of your opponent's argument is that this degloving injury really is so unusual because there was not the tendon or muscle or other damage that typically goes with them. Can you respond to whether you agree with that description in the total universe of comp cases? And second, does it matter?
Absolutely, Your Honor. I believe just from a medical standpoint that it was not exclusively limited to the skin. I mean, clearly a fairly severe injury to the upper arm also involves the nerves. He was treated for nerve pain, took nerve pain medication. And also I believe that the experts rating Dr. Bansal, who provided opinions on behalf of the claimant, part of his rationale behind the impairment rating that was ultimately accepted was a loss of grip strength and other factors that would go directly or beyond just exclusively the skin. And I think even if there were an injury that affected exclusively the skin, a rash or some other type of skin condition, if the effects of that condition or that injury are limited to the scheduled member, then the outcome would be the same. So while even if it's a psoriasis or something like that that could more globally or entirely affect the skin beyond the specific confines of a scheduled member, then it could be a different scenario. And the Delaney court provided an example of that with a case of complex regional pain syndrome infecting the entire nervous system, and that being the key, that it infected the entire nervous system rather than being limited to, I have CRPS that causes pain to my arm only. In that case, presumably the answer would be different.
So as I understand your argument, you do leave room for the idea there's some global skin condition, not these facts, but some facts that might fall within your opponent's argument.
Yes, I think that the Delaney case sets forth that case-by-case approach, that analysis, and determining where is the functional loss here. And here, even the claimant's expert, Dr. Bansal, in assigning the impairment rating accepted in this case, right above it is the heading right upper extremity, right lower extremity. It was even explicitly mentioned in that opinion that this is the body parts that this injury affects. It's not a global condition. Where I think it is very, very analogous, the decision in Delaney with an injury yielding an impairment rating expressed to the whole person that is not per se a body as a whole injury, not to say that it could never be, but it is not per se.
Didn't talk about paragraph X, though, and sort of the direction that we have to rely on the AMA guide. So can you briefly talk about the impact of that and what weight we should give to the whole body impairment rating that came from the AMA guides given paragraph X?
Paragraph X concerns how much, not what kind. It's a measurement or measuring the extent of or the percentage of permanent impairment. It has no bearing on the classification of the injury as scheduled versus unscheduled. It's merely taking the discretion out of the hands of the deputy commissioners to elect to choose their own impairment rating, one not provided by physicians using the guides. Oh, pardon me, I've run out of time. Thank you.
Any rebuttal?
Yes, Your Honor. Thank you. I want to talk a little bit about Delaney. We would agree that it's a different statute that was being used, but it's also important factually speaking. In that case, there was 2 ratings. The injured worker in Delaney did receive a body as a whole rating. That was a 3% for the vascular system under the AMA guides. But they also had a 37% leg rating as well. So in that situation, you had 2 ratings. One, which was to a body part on the list, and one that wasn't. And that's why it was kicked back down, because you had two different ratings. You had a body as a whole rating, and then you had a rating to the leg. This is not that case. In this case, we only have a Chapter 8. And when I say Chapter 8, I'm talking about the skin chapter. We only have a skin chapter rating, and both experts agree to that. Both experts agree that the appropriate AMA guides was not an arm. It wasn't the leg. The agency used its discretion, and it's not supposed to use its discretion under 8534-2X. It used its discretion to find this loss of use to Laguerre, and they found it was an arm and a leg. And Mr. Workman talked a lot about the functional use. If there was functional use impairment to the arm or to the leg, the doctors would have used those chapters. I believe the first case before us, they talked about an inappropriate use of the guides and how there was, if you did a neck chapter to an ankle chapter, those would be incorrect. You can't do those. Just in this case, both doctors couldn't use any other chapter other than Chapter 8, because what we have here is a degloving, just a layer of skin. If you see the pictures in the certified record, you'll see there's just muscles and fat showing, right? There's no deeper structure.
Your opponent's point that there were some neurological injuries, for lack of a better word. It wasn't really just skin.
It was definitely just part of the skin. It was the organ. The organ of the skin has blood vessels. It has nerve endings. If you scratch your hand, or your arm, yeah, it hurts because it has nerves. But it's still part of that organ, just like other organs in our body have blood and nerves and things to that nature. So it is a purely Chapter 8. All the agency concluded, as a matter of fact, that Chapter 8 was the right chapter to use. They adopted the rating of Dr. Banzel, which was 7% body as a whole. The skin chapter only allows for body as a whole ratings. We're not purely relying upon that. But I think it's important to see the defendant's expert was rejected because they anticipated just an arm. The defendant's expert used some percentage of how much skin is being lost and try to work it into just an arm rating. And the agency says that's not what the guide says. They knew what was anticipated. They knew that a body as a whole rating is the only chapter 8 only gives that. However, the defendant's expert anticipated to just bring it to an arm rating, and that was rejected by the agency. Talking a little bit about just generally the court's responsibilities, it's not this court's duty to patch up any legislative deficiency or any type of anticipated litigation abuse. What we're talking about here is the statute before us. And the body part, the organ that was permanently affected in this case is not on the list. And if it's not on the list, then it has to be an unscheduled injury. And we know that the agency can't use its discretion and say that it's an arm or that's in a leg. That's a completely different chapter in the AMA guides. It would have been inappropriate for them to use a rating in the arm and the leg. We would ask that this court reverse and remand back to the agency and deem that Laguerre sustained an unscheduled injury and that an industrial disability analysis and all other issues that the agency can determine. Thank you.
Thank you, counsel. Thank you both for your briefing and also for your arguments this afternoon. We will take this matter under advisement, and we'll have a ruling out on it as soon as we are able. At this time, that does conclude oral arguments for this session, and so we stand adjourned.